Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-5058, League of Women Voters of the United States et al. Versus Stephen Frid in his capacity as the Executive Director of the United States Election Assistance Commission et al., Eagle Forum Education and Legal Defense Fund Appellant. Mr. Joseph for the appellant, Ms. Lopez for the appellees.
Good morning, counsel. Mr. Joseph, please proceed when you're ready.
Thank you, Your Honor. Lawrence Joseph for the Appellant Eagle Forum Education and Legal Defense Fund. May it please the court, there are, I think, 3 two-part questions and then a 6-part test that are the key issues here. The 3 two-part questions are we substantively, are we dealing with the First Amendment or the common law right of access? On the attorney-client issue, there are 2, I think, key issues, many issues, 2 key ones. One, is there a dual hat relationship where DOJ was essentially working as or working with the agency to make law, to decide cases as opposed to counseling in a litigation capacity? Or, and that's one, and then 2, whether if indeed there was an attorney-client relationship, was there some sort of fraud, misconduct, anything that would vitiate that? The third two-part question is about the mandate from the this court's Newby 2 decision. That's where my client's intervention was granted. And I think the 2 mandate questions or related mandate-related questions are, did the remand to the district court presume that given that my client would then be an intervener, which is not the public, that's some form of party, maybe not a full party, but certainly some form of party, were they entitled under the protective order as written to have access to the sealed materials? That would have helped, obviously, the briefing. And then second, on the mandate, this is more law of the case. We argued initially, when we moved to intervene, that the court could unseal without looking at Hubbard because of the alleged fraud in the 10th Circuit. And so the unsealing could be done as a sanction because the party didn't have clean hands. The sealing is equitable relief if the ESE came to that court with unclean hands about being duplicitous in the 10th Circuit, then they might not be entitled to seal. The district court on remand was bound by this court's mandate under the mandate rule to follow, to work out the Hubbard factors, which we're getting to. But this court, on further appeal, you're not, I don't think, bound. I mean, you can choose to bind yourself to the Newby 2 decision, the intervention, saying, let's look at Hubbard, but you don't have to. You could decide that what was done here and in Colorado in the 10th Circuit was sufficiently disingenuous that we're going to go the sanction route. So then that brings...
It involves an abuse of discretion standard, which is a very high standard. And then when you look into the Hubbard factors, how do we get there on abuse of discretion? Because you're coming in as generally a non-party first, does not give you any more rights, essentially, than a party. But then also the court below suggests that, you know, this could be a fishing expedition. And then even more importantly, that it did not use the documents for the ruling.
Okay. So first off, I mean, my client publishes about this issue. So we're like the Washington Post in a sense, and the public has a watchful eye interest under Hubbard itself. The more recent Los Angeles LA Times case talks about, I don't have the language in front of me, but again, there's a public interest in making sure agencies behave, and that is shared by everyone. As to didn't use, that may be true. It didn't need to be true. The court could have remanded without vacating. The court could have retained jurisdiction. So some of this issue, so let's back up. Newby won the preliminary injunction appeal in this court was a preliminary injunction case. So under, I'm not sure I can pronounce this, but Kamenish, University of Texas versus Kamenish, what's decided in a preliminary injunction case doesn't necessarily decide the merits. So the fact that, hey, no necessity finding, which is something that the EAC needed to have in order to approve the documents in question in the underlying litigation. If they didn't have that, then there would be a preliminary injunction, I guess. But that didn't mean that that didn't resolve the case. They could have remanded the agency, had to see if they could make a necessity finding and then come back. Or they could have just dismissed as they did. So that it could have been used, and it was offered with the intent that it be used. Under factor 6, it's why was it offered? Under factor 1, there's this public interest separate and apart from the underlying case. So in the LA Times case, is a senator misusing information, I forget if it was a he or she, that he or she got from their privileged position in the Senate. That wasn't what the case was about, but it was related, and there's a public interest in that. And then, of course, in the fourth factor, which is perhaps the biggest one in the series for this case, at least, that is, there's the issue of, was there an attorney-client relationship because of the lawmaking, adjudicating function that DOJ was essentially ghostwriting, according to my understanding. I mean, I don't have access to the document, so I don't know, but that was one of the questions in the 4-part question about the depositions. I'm sorry, so did I answer the question?
Yes,
okay, right.
Thank you.
Should I go on with mine or okay. So this is, we think, Hazel Atlas on steroids. Hazel Atlas is the paradigm fraud in the court case. They're a patent holder planted an article in the trade press and then cited it to defend their patent. Here, it's markedly worse. First of all, and it is not these counsels, so I don't even want to refer to them. This was someone else at DOJ. It was not the Federal Programs Branch. But they have a burger duty to win fairly, or to litigate fairly, more than to win, under the United States versus Berger. That's been applied to agency defense by this court in Freeport, McMorran Oil. Anyway, and so in addition to the, hey, Palace of Justice, lawyers shouldn't lie, any lawyers, there's also a separation of powers issue there, because they're pleading deference to the agency, the independent agency, when in fact it was written by politicized DOJ. There's also federalism, which is, this is trenching state power by the federal government with regards to their voter registration issues. So it's worse than Hazel Atlas in that regard. As far as the so-called concessions, again, both, I mean, the DOJ tried to say that my client conceded something by saying that this didn't come up in Newbie 1. That is a preliminary injunction case, as I said. It's not binding on the merits, such as the remedy. And similarly with then Secretary of State Kobach's concession about, yeah, I guess you can get to the merits. Again, it was in the preliminary injunction hearing, and even there, he says there are some ridiculous assertions of privilege, such as things that are already in the record or already released. So some things have been withheld in these sealed documents that shouldn't have been withheld. And then there's also the questions, and this is important for the next stage. If we lose here, we would petition for cert if we don't get an answer. But if we get to see the questions, at least, we might realize that we don't care what's in this document. Is it a fishing expedition? I guess we don't know what we're going to get. So in that sense, it is. But in the other sense, it is. We feel that that there's a non-transparency, and we ask this court to help make that process transparent. Thank you.
We'll give you some time for rebuttal. Ms. Lopez.
Sorry, it'll just take me a second. May it please the court, Carolyn Lopez on behalf of the government. Consistent with this court's instructions to apply the Hubbard factors on remand, the district court correctly denied Eagle Forum's request for disclosure of the sealed materials. Because the sealed materials, as the district court emphasized, did not affect the resolution of the case on the merits because the district court did not rely on them, as in the district court's view at the behest of the parties, which told the district court he didn't need to rely on them, which this court has recognized most recently in CNN can be the most important and, in fact, an almost dispositive factor in the decision to maintain the seal under the Hubbard factors. And in addition, the government had, of course, lodged substantial claims of privilege. While on the other side of the ledger, Eagle Forum failed to overcome those interests in maintaining the seal, based solely on, as the district court described it, its speculative claims that DOJ had somehow engaged in misconduct by offering advice to its client agency on a remand that the agent, on a determination the agency was making at the behest of a court-ordered remand in ongoing litigation. And that's not government misconduct to provide advice to a client agency in the course of ongoing litigation. And that's, the attorney, the heartland of the attorney-client privilege, of attorney work product, and also just the general deliberative process privilege. That agencies can consult with other government actors in making its determinations. And here, the record evidence by the decision maker herself confirmed that she made that decision after consulting all relevant resources.
Can I just ask you, on the other side mentioned the First Amendment at the outset of the argument. I take it from your submission, the sense that the First Amendment would add something to the Hubbard analysis so that it would ratchet up the standard or do something different. You think that was forfeited?
Yes, Your Honor, that was absolutely forfeited. So this court, of course, in the prior appeal, remanded for an analysis under the Hubbard factors, and at no point before the district court did Eagle Forum suggest that applying the First Amendment instead of the Hubbard factors would alter the analysis. So that question is certainly forfeited, as we argued in the brief.
So even though the First Amendment was mentioned, it wasn't developed in a way that would suggest that it was something that would differentiate the analysis from what would normally ensue under Hubbard.
That's exactly right. So there were no arguments that there would be a different, that the First Amendment will require a different sort of analysis than this court has traditionally applied under the Hubbard factors, and particularly in the civil court context in which this court has sort of repeatedly said that it doesn't need to address whether or not the First Amendment would play out any differently. And so that issue was certainly forfeited here.
Okay. Let me sure my colleagues don't have questions for you.
Thank you.
Thank you, Lopez. Joseph, will give you 2 minutes for your rebuttal.
So it did not affect the merits, but it could have. It was under Factor 6. It was offered so that it could affect the merits. Under CNN, can be does not mean is. It can be, but in this case, it isn't. The substantial claims of privilege and speculative fraud. I mean, they said, trust my client, the expert, nonpartisan entity, and at least under the Newby Declaration, which is all we have, DOJ wrote it. DOJ does not have the right to say whatever they think. I mean, they haven't been given a leg up in litigation. They have a client that has a leg up in litigation, but if they take over that task, they have to disclose that they wrote it. Again, as in Hazel Atlas, only more so. As far as the forfeit of the First Amendment, the remand was, we've argued the First Amendment, I believe, throughout the case. The remand was for Hubbard. That's what was sent back, but that doesn't bind this court. This court has the right to decide, actually, we're going to do a sanction. Actually, we're going to do the First Amendment. And whenever one of these cases comes up and the person seeking disclosure loses, then I suppose you don't have to look at the First Amendment. Oh, I'm sorry, I got that wrong. When they win, you don't have to look at the First Amendment. But if they're going to lose and the First Amendment is different, such as narrow tailoring, then it is a second step in the analysis and one that they can't possibly win. This wasn't narrowly tailored. It didn't even require them to show privilege. So as far as the misleading the 10th Circuit was very clear.
But have we ever said the First Amendment applies in the civil context?
We have, yeah.
Okay.
I'm
Care to-
out of time, I believe.
You can answer the question.
Oh, I'm sorry. I thought I did.
Well, I mean, you said we have, but you want to just further elaborate on that? Because it didn't seem very clear to me.
I don't have a page number, but I could
Okay.
submit it in a
But your
letter.
answer is yes, I'll take that. Thank you.
Thank you, Your Honor.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 23-7040, Campaign Legal Center Appellant versus 45 Committee, Inc. Ms. Danahy for the appellant, Mr. Lucas for the appellee.
Morning, counsel. Ms. Danahy, please proceed when you're ready.
Good morning, Your Honors, and may it please the court. Molly Danahy for the Appellant Campaign Legal Center. This court should reverse for two reasons. First, the district court had no basis for redetermining whether Campaign Legal satisfied the statutory prerequisites to bring this suit. Second, the district court erred in determining that the FEC acted during the conformance period despite failing to obtain the majority vote required for it to exercise its authority under FECA. With respect to the first issue, the district court erred in finding that it was obligated to double-check the work of the delay court in order to establish its jurisdiction over the citizen suit. As an initial matter, the statutory preconditions for a citizen suit are not jurisdictional because they do not contain a clear statement of congressional intent to limit the federal court's ordinary obligation to hear claims arising under federal law. But even if they were, FECA's text and structure clearly assign the responsibility for judicial review of FEC action the delay court, while limiting the citizen suit court to determining a defendant's liability for substantive FECA violations. As such, all the citizen suit court is required to determine is whether the plaintiff brought and ultimately prevailed in the delay suit, allowing, much less requiring, the citizen suit court to second-guess the decision of the delay court is contrary to the text of FECA, to the purpose of administrative exhaustion requirements, and to the normal course of judicial review. With respect to the second issue, the district court erred in determining that the FEC acted when it deadlocked on whether to find reason to believe during the conformance period. By statute, the FEC cannot exercise any of its duties or powers absent a majority vote. Treating a deadlock vote as agency action contravenes the statutory requirement. Dismissing an administrative complaint is indisputably an exercise of the FEC's duties and powers, and thus dismissal cannot occur absent a majority vote.
But aren't there cases that support that a deadlock can be a final agency action?
Yes, Your Honor. I believe in the FERC case, this court has suggested that. But in that case, that was a case about whether a deadlock is action and when the FERC engages in it. It did not involve the FEC. The FEC was not a party to that case. And the court was not required to wrestle with the two-step process that the FEC engages in when it dismisses after a deadlock.
And I'm kind of concerned about kind of the political piece to deadlock, because if you never get to majority vote, it just leaves any decision just kind of hanging. And so it's almost as if commissioners, if you fail to vote too, don't allow the parties to proceed.
Well, Your Honor, I think that's a function of the way that the statute is written. So the FECA requires a majority vote for the FEC to take any action, and it includes the private right of action as a check on deadlock, essentially. The FECA was written and to be bipartisan, to require bipartisan support for agency actions, and it also imposes a heightened vote requirement for certain agency actions. And that was to ensure that when the agency engages in review or action on administrative complaints, it does so in a bipartisan manner. That includes dismissal. Because of the majority vote requirement, when the commission is acting as a 6-member majority, it requires a 4-vote majority in order to dismiss an action. And the citizen suit provision exists to ensure that when deadlock occurs, there still can be enforcement of FECA through a private suit to represent individual rights.
Well, if the perceived reason the determination was contrary to law is a failure to act, then why isn't just the holding of a reason to believe vote the action?
Well, Your Honor, just holding a reason to believe vote is not agency action because nothing occurs just by holding the vote. There's no, holding the vote does not, when a deadlock occurs, the administrative complaint isn't advanced through the administrative enforcement process and it's not dismissed. Literally nothing occurs. I think the FERC cases.
But some things occurred that didn't occur before. I mean, it seems like an outright failure to act means nothing happened. But when a reason to believe vote is held, then something happens. It may not do all the things that you say. It could be done. That's for sure. You don't know what's going to happen when you hold a reason to believe vote. But it does seem like it's something where the failure to act determination was predicated on the notion that there was a nothing.
Well, Your Honor, I think there's a difference between doing something, as the other side has suggested is sufficient, and taking agency action, which is required to conform to the delay court's order for failure to act. And that's because agency action under the statute requires a majority vote. The agency cannot exercise its duties or authorities absent a majority vote simply by holding a vote that has no legal effect, that doesn't constitute agency action in the sense of what the statute contemplates. And that holding that it would, it's just opens the definition of action to an incredibly broad array of things. Does an FEC commissioner emailing another commissioner about the matter constitute agency action? Does putting it on the agenda and then removing it for consideration at an executive session constitute action? You know, those are things that do not have any legal effect. They do not have any effect on moving the complaint forward, either through enforcement or closing the file through dismissal. It doesn't. There's no effect of that holding the vote when it ends in deadlock. If you hold a reason to believe vote and 4 commissioners vote to advance that through the enforcement process, that would constitute action. If you hold the reason to believe vote and the commission deadlocks, but 4 commissioners or a majority of commissioners vote to dismiss the case, that would constitute action. But simply holding the vote is not sufficient to remedy a failure to act because it has no practical or legal effect on the complaint itself.
But we already know in some situations, at least, where there's a holding of a reason to believe vote, even if there's a deadlock, there can still be a review, judicial review.
I don't believe there's ever been a case where this court has reviewed an agency deadlock that wasn't subsequently followed by a majority vote to dismiss the case.
Yeah.
So agency review is not triggered by the deadlock. It is triggered by the dismissal of the action.
But notwithstanding that the vote resulted in a deadlock, there can still be review.
Notwithstanding the fact that the vote resulted in a deadlock, there can be agency review, or there can be judicial review if a majority of the commission votes to then dismiss the case and submit it essentially for judicial review of the
And you don't think a
complainant.
deadlock can essentially mean a dismissal?
No, Your Honor, I think that contravenes the clear, plain text of the statute, which requires the agency to act by majority vote.
Can I take you back to the first issue? So even if we agreed with you that that it's not jurisdictional at the citizen suit stage, it still seems like there could be review in circumstances like those in this case, where you have some new facts come to light and where it's a non-party. And in fact, it seems it's pretty parallel to the situation that we had before us in the Heritage Action case. And that panel did say that in these kinds of circumstances, there wouldn't be a preclusion against review in that second round proceeding. in pretty parallel factual circumstances.
Yes, Your Honor. In that case, the question was not presented whether, like in heritage action, the question was not presented whether the citizen suit court is obligated to redetermine the facts of the delay proceeding in order to establish its jurisdiction or in order to establish the plaintiff has satisfied the preconditions. There, it was just a matter of whether the party would be precluded from raising the issue. They had already done so by that point in the citizen suit. And I think that was informative of this court's decision that there was no need for intervention in the heritage case.
But we said heritage action was not a party to the default judgment in Campaign Legal's lawsuit against the commission. That's the same as this case.
Mhm.
And would not be prevented from arguing that section 3109A8C's prerequisites have not been met. That
Yes.
is the question, right? Whether.
Yes, Your Honor. And I think, again, the issue there is about like the classic sort of issue preclusion. They would not be collaterally stopped from raising those arguments. We're not arguing kind of that classic collateral estoppel issue here. What we're saying is that the statute creates a specific, Congress created a specific statutory scheme for agency review that is fully completed and done within the delay court proceeding, and that there is no place or reason for the citizen suit court to reopen those facts or relitigate that decision under this statutory scheme as set up by Congress.
My colleagues don't have additional questions for you. Thank you.
Thank you, Your Honor.
Time for rebuttal. Mr. Lucas.
Morning, Your Honors. May it please the court, Brenton Lucas for Appellee 45 Committee. I'll just start with the last question that we were discussing with my friend on the other side about heritage action. And in that case, briefs did clearly discuss that in that context, Campaign Legal Center was trying to argue in the citizen suit that you could not raise this argument. That was in fact the reason heritage action was pursuing an appeal of the intervention denial, because it wanted one bite at the apple. We're in the same situation. We want a chance to be heard on this issue in light of the new evidence that's come to pass. And we think that this issue was considered in heritage action. The briefing at least touched on the fact that Campaign Legal was trying to prevent a similarly situated non-party from raising these arguments in the citizen suit. And this court, I believe, passed judgment in the passage you cited. So I think that heritage action is probably the easiest way to deal with all the preclusion arguments here.
Well, all the opinion says is that you can raise the argument. It doesn't say that the district court has to hear it.
Well, I think the reasoning given by this court in heritage.
That's implicit in the statement of the court?
Well, the reason given by the courts was that we had two rationales for why we could argue this in the court. One was the fact that we weren't a party, and the second was that it was a default judgment, so that we could raise this argument there. So I think the reasoning carries over, saying that yes, you can raise it and the court can indeed hear it.
You can raise the argument, but that doesn't mean that the court has to credit it. The court could say, well, it's a default judgment. You've raised your argument, but I'm going to reject it.
Certainly on the merits, yes. We're not saying that the court was bound by any sort of sense of the delay court on the merits. We were just saying that we have a chance to make that argument. That's all my point is right here. And so turning to the merits, I do think, as Judge Childs referenced, that public citizen is a good starting point, and I think also the stopping point here. And I'd like just to respond to my friend's argument that that was dicta. Because what happened in public citizen was this court had to determine its jurisdiction over a FERC case. Yes, it was a FERC case, but the petitioners there argued that, look, because this whole question of jurisdiction turns on whether a FERC deadlock is in fact an agency action, they said you should treat FERC deadlocks like you treat FEC deadlocks. And this court said no. And the reason they said no wasn't because FEC deadlocks aren't action. It's because FEC deadlocks were different from FERC deadlocks, and it spent pages explaining the difference between those two. And so that was a necessary part of this court's reasoning to get to its holding that it in fact lacked jurisdiction. If it just thought that all agency deadlocks were non-action, if it thought FEC agency action, or excuse me, deadlocks were non-action, it could have just said so and ended the case on that basis. Even if going beyond public citizen, I'd also just point you to New Models, this court's decision, where it rejected the identical argument there raised by Crew, which Crew, citing 30106C, said, look, when the FEC deadlocks on a vote and it doesn't lead to either a dismissal or an enforcement action, basically what happens, it's a nullity. It's a non-action, nothing happens. And this court squarely rejected it, relying on its precedents discussing the controlling commissioner doctrine. Yes, it also relied on this particular four-commissioner voting requirement in the statute, but it went more broadly and also cited this court's precedents on controlling commissioners. But even beyond that, I think in just going to first principles, I do think that CLC's argument here would essentially gut FECA's reticulated enforcement scheme. Because under their position, right, all you have to have is a partisan minority of just 3 commissioners, or perhaps even less, depending on the commission, and you can engage off green light private enforcement of FECA, notwithstanding any of the various bipartisan veto gates that the statute sets up to go through before the FEC can take an enforcement action. And I think that's particularly problematic. And I don't think my friend has any answer to that. I think her best argument is to say, look, yes, that's true when it comes to the FEC, but not when it comes to citizen suits. But I think from our perspective, we would be far rather litigating against the FEC than a particular citizen suit, because that could be any private party, ranging from defendants, diehard political adversary or not. And in that context, those private litigants aren't bound by any of the sort of procedural norms of government attorneys, of the prosecutorial discretion that's covered by that. I think just as an illustration, you can look at the general counsel's memorandum here. And I think it's very restrained and comparatively to what CLC is arguing here. There, the general counsel said, look, based on the evidence, we think that there is at least some reason to believe to conduct an investigation. But it didn't go on to denounce my client and say that, look, it's clear that 45 committee violated the Campaign Act. And so I think that just sort of underscores that when Congress set up this very reticulated scheme in this sensitive area involving First Amendment concerns and involving the inherent nature of partisan enforcement, the dangers that poses, it didn't want all of that to be thrown out by this sort of scheme where you can use just 3 commissioners to greenlight and trigger enforcement actions by private parties. And so
there was an intentional withholding of information by the commission to publicize the tie vote. Is that right?
Yes, and I think that was a key part of this aspect. And the delay court.
And the reason they withheld it, at least according to a newspaper report, was in order to allow a citizen suit to be brought. Is that right?
Exactly. And just to underscore that.
Why isn't that fraud on the court?
I mean, we do think that it certainly approaches fraud on the court, and that it's
doctrine has mostly been applied, maybe always, to a party. But in one sense, the FEC is a party, and it is committed a fraud by withholding the information.
Yeah, certainly, Your Honor. I mean, I don't think this court even needs to go there. I think we have all sorts of other issues. But just to underscore why I think this was particularly problematic is last year, this is following a change in leadership. That's the only reason we ended up getting the records, is that Commissioner Lindenbaum, one of the Democratic appointees on the committee, replaced another Democratic appointee. And when she got on to the commission, she cleaned house and she released the files in all of these cases. The evidence came before Judge Mehta. He was able to see and figure this out. And then she also voted to adopt a policy that going forward, when the FEC takes these deadlocked votes, they're going to provide them under seal to the court, even if it's still ongoing, so that the courts can at least know what's going on. And so I think that just sort of underscores what happens is that everybody, this isn't a partisan issue, that the FEC realizes that what was going on here was a scheme to deliberately mislead the courts into thinking that nothing had happened.
Isn't there a pending, that issue's pending, right? Didn't the district court in the other case?
Yeah, so again, you don't have to get into this, and I think Judge Mehta was very clear that we don't have to decide whether this was unlawful or whatnot. All you have to decide is that, look, Judge Mehta had the evidence in front of him, and he said, now I know this wasn't before the delay court, but I can at least review these records, and based on circuit precedent, this is unquestionably a conforming action.
Isn't there another doctrine that could take care of it, that newly discovered evidence?
Certainly, yes. That's another argument and another basis that he had to consider this. I think there's multiple grounds for why he could consider this, and this evidence wasn't presented. I mean, the delay court, just understand, the delay court thought that the FEC hadn't taken any vote other than at most a vote not to defend, because it was under the impression that when the FEC votes on a complaint, whether to engage in an enforcement action, it discloses that, or at least it should. But again, we don't need to get into whether the FEC engaged in misconduct here. That's not presented in this case. All we want is for this court to just affirm the judgment and say, look, this citizen suit is over. As Judge Maida said, whether this is a dismissal or whether there was fraud or whatnot, this is action under circuit precedent, and that's good enough for today. And I think that's what we want. My client would be happy with that. Yes, I think that's all this court needs to engage in.
My colleagues don't have additional questions for you.
Thank you, Your Honors.
Mr. Lucas. Ms. Danahy will give you 2 minutes for rebuttal.
Thank you, Your Honor. I'd like to address first the other side's argument that allowing a citizen suit to go forward in this case would vitiate the bipartisan kind of veto checks in FECA. And I think the important thing to remember is that the majority vote requirement to dismiss a matter is one of those checks. And so too is the 4-vote requirement for the FEC to defend itself against lawsuits under 30109A8. And those two statutory provisions ensure that a citizen suit can proceed when the FEC is helplessly deadlocked and they cannot take action on the case. And so to the extent my colleagues are frustrated by the way that this case is proceeded or the way a citizen suit comes into effect, their complaint is with the statute and not with the actions of the commission or any action by our client. And I would also add that with respect to whether there was any concealment of the administrative record from the delay court, there was not. And I think that is clear, again, if you look to the FEC's requirements for when, or for FECA's requirements for when the FEC must disclose information to the parties in the case. It must disclose to the respondent when it votes to find reason to believe or votes to find probable cause and advances the case through the administrative process, and it must inform the parties when it votes to dismiss the case and closes the file and releases the administrative record. None of those things occurred until after the citizen suit was brought, and so there was no concealment or fraud on the court. Again, the complaint with the way the FEC handled the disclosure of information is with the statute itself, not with the information that was before the delay court. The delay court had every right to, on the information before it, in a default judgment, find the FEC, who did not appear to defend the case, had failed to act and failed to conform with its order to do so. And that was all that needed to happen for the citizen suit to be brought. Thank you, Your Honor.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 23-1192 et al. New York State Public Service Commission petitioner versus Federal Energy Regulatory Commission. Mr. Schwartz for the petitioner, Ms. Mary for the respondent, Mr. Hughes for the intervener.
Morning, counsel. Schwartz, please proceed when you're ready.
Good morning. Thank you. May it please the court. Jeffrey Schwartz for the New York State Public Service Commission. I'd like to reserve 2 minutes for rebuttal. The orders on review here raise rates by hundreds of millions of dollars because of a speculative assumption that New York will force fossil fuel generators to retire by 2040. But FERC has never found that New York must, that New York will, or is even likely to force such retirements by then. The remand order found no record evidence for that assumption, and the later orders agree. The May 19th order held that the zero emission target can be achieved in more than one way and does not require all fossil fuel resources to cease operating. The October 4th order similarly held, we continue to find that the Climate Act does not require all fossil fuel resources to retire by 2040. And FERC agreed with extensive evidence submitted by the Market Monitor that in 2040, New York will still need large quantities of dispatchable thermal resources to preserve reliability. Now, if New York does not require retirement by 2040, if, for example, it adopts a net emission framework that allows some fossil fuel resources to keep running, or if it keeps the fossil fuel resources around on standby as a reliability backstop, or if it requires retirement by 2043 instead of by 2040. In each of those cases, consumers will have been forced to pay hundreds of millions of dollars that were never needed and that they can never get back.
So has any of that happened yet?
No, those questions have not been answered yet.
Right, so which way does that cut? Because if those questions haven't been answered yet and they haven't been teed up, it seems like what the commission ratified makes some sense, because even in the way that we remanded the case, you take the existing state of play as a given, and you don't sort of project forward to anticipate things that haven't come about.
Correct, but the existing state of play when the system operator filed in November 20 was a law that does not regulate generators at all directly. There are no, it regulates only the New York agencies and tells them to regulate to achieve two goals. And as it pertains to the New York Commission, the Climate Act put forward two goals that the Commission has to pursue simultaneously: reducing emissions and protecting reliability. And at every stage of the implementation, when the initial program was due in mid-2021, which was 7 months after the system operator filed, and every 2 years thereafter, when the New York Commission reviews the program, it's supposed to consider reliability along with reducing emissions. And frankly, if those things conflict, reliability wins. New York is not going to turn out the lights in New York in order to hit the zero emission target. So the reason why uncertainty cuts in favor of maintaining the existing pre-act amortization period is that doing it the other way risks charging customers hundreds of millions of dollars that were never necessary for them to pay, right? Because let's say that New York were to decide tomorrow that allowing these resources to continue, that they could continue in operation. Presumably in the next reset, the amortization period would revert to 20 years, but there would be no way for customers to get back the extra charges that were imposed using the 17-year period. But if you do it the other way around, the generators are not at risk. If New York tomorrow were to say, in fact, yes, by 2040, all the fossil fuel generators will retire, then in the next reset, the numerator is still the same. The numerator is the full cost of entry of the hypothetical peaking plant. And the denominator isn't 17 years anymore. In the next reset, the denominator is 13 years. So the rates are going to be calculated in the next reset at a level sufficient for the generators to recover their costs. And I know that the agency says that the zone of reasonableness is a range, and that's true, but there are limits. And the most basic one is that the Federal Power Act requires balancing investor and consumer interests. That requirement is why it's wrong to conflate the zone of reasonableness with what a reasonable investor might do. The investor perspective is only half the equation. Consumer protection is why FERC's no speculation precedent holds that speculating about future regulation can't justify a rate increase today. The need to protect consumers against potentially unnecessary charges is what takes the increase outside of the zone of reasonableness. The speculation makes it unreasonable. And the final point, the final limit on the zone of reasonableness is the evidentiary record. FERC here concluded in the remand order, I think it's in paragraph 31, that dispatchable resources like these will be needed for reliability, which makes it unlikely to presume that they're going to retire by 2040. The orders on review ignored these limits. They inquired only what an investor might think, not what's fair to consumers. And they answered in a way that speculates what New York will do and blinds itself to the evidence that the resources will be needed. And FERC then treated the result, a multi-$100 million rate increase, as just unreasonable per se. The flaws in FERC's reasoning are revealed by considering the fact that FERC held that the existing 20-year amortization period remains reasonable. That tells you several things. First, it says that the foundation for the 17-year period is shaky. If you knew that the resources were going to retire by 2040, then a 20-year period wouldn't be reasonable. The second thing it tells you is that FERC believes the system operator can run the system reliably today on the basis of the 20-year amortization period. And that means the shorter period and higher rates are unnecessary. The bottom line here is that this rate increase is based on forecasts of regulatory action that New York has not yet taken and may never take, and that the system operator can take into account if New York eventually does take. Because raising rates needlessly is not just unreasonable, the court should vacate FERC's orders.
Thank you, counsel. We'll give you some time for rebuttal. The commission now, Ms. Perry.
Thank you, Your Honor. In its remand decision, this court said that all the New York ISO needed to demonstrate in this proceeding was that the amortization period represented a reasonable estimate of the number of years that an investor would inspect a gas-fired plant built in New York between 2021 and 2025 to remain commercially viable. The commission reasonably found that the New York ISO met that standard here because of the fact that since the last reset proceeding, there had been passage of an act that required that there be zero emissions by 2040.
But there were implementing regulations that still hadn't come to fruition yet.
Exactly, Your Honor. But you have to remember that the point of the amortization period is to represent investors' expectations of risk. It's to compensate them for risk. And what you want somebody to do is today have the incentive to build a plant. And the point is the investor looking today to build a fossil fuel plant is presented with the current circumstances of there is a 2040 zero emissions requirement. There are no regulations that permit them to meet that requirement any other way other than by ceasing operation. Because there are no regulations that permit them to modify their facilities and continue to operate, there are no regulations that permit fossil fuel plants to continue to operate after 2040. So the point is, what the New York ISO said, as this court said in its remand decision, thus the developer of a fossil peaking plant would face substantial uncertainty about the financial returns of a fossil peaking plant starting in 2040. And that is the concern that the New York ISO was addressing, because you want all of the investors to have adequate incentives to build a fossil fuel plant now. And the point is, if there are regulations, as the commission said, that come on later on, that is why there are periodic resets. And new regulations that come on that don't exist now but do exist later can be taken into account in the next reset proceeding. And I believe
this may be something to ask the petitioner's counsel too, but has anything concrete happened by way of regulations?
And to my knowledge, Your Honor, what I know is that recently in 2023, the New York Public Service Commission had a proceeding in which it asked for comments on the scope of the zero emissions requirements and the scope of what constitutes the the energy system, the electric system under the statute. And they asked for supplemental comments on that. And my understanding is that those supplemental comments were just filed. The due date was January 19th of this year. So I don't believe with regard to the issue.
I thought that this Climate Act required them to set up a program by June of 2021.
It does, Your Honor.
And if they had done that, then they wouldn't be here, presumably, because they would have had the regulations in place, and you could tell exactly what the situation would be unless they'd be repealed or changed or modified over the years. But because they didn't do that, they didn't comply with the act, the ISO had to submit every 4 years the information regarding what the amortization would be, right?
That's right, Your Honor. And the point being that they do that under the commission's regulations in this court's remand decision based only on the laws and regulations that currently exist. And at the time, as the court said, at the time, there was the New York Public Service Commission had not modified the 2040 zero emissions requirement and had given no indication that it planned to do so.
Which is still the case.
Which is still the case. And you will notice in their pleadings in this case, the New York Public Service Commission never says, we're intending to modify these requirements. They're just saying we might, the statute permits us to, but we haven't decided. And so what the New York ISO has to do is to make investors now, investors who are building a fossil fuel peaking plant now, have sufficient incentives to build. And what they do that by making sure that the risks are adequately compensated. And right now, to an investor building a fossil fuel peaking plant, you have to say the passage of a statute that says zero emissions by 2040 is a risk to them. It's an additional risk that didn't exist before. And the New York ISO is taking that risk into account in lowering the amortization period to 17 years.
But how does this affect the anti-speculation precedent that's out there?
Well, the anti-speculation precedent, actually, the commission found ultimately, as this court in the remand decision said, any speculation about future actions by the New York Public Service Commission to implement the statute are squarely inconsistent with this commission's anti-speculation precedent. And so on remands, the commission said, following the guidance of the court in the remand decision, we find that the New York ISO is properly looking at the current state of affairs, which is there is a 2040 zero emission requirement. There are no regulations modifying that requirement and no regulations permitting anybody to be excused from that requirement.
But the implementing regulations haven't been passed.
That's right, Your Honor.
This is always speculation, isn't it? I mean, you're making a projection about what the future is going to hold. You know, and maybe if you only project the future for the next 10 minutes, you're not speculating, but if you're talking about years, you absolutely are. And no matter which way you cut it, if you comply with the commission's position, you're speculating that the 2040 requirement is going to be changed. If you're doing what the commission did, which is we're going to assume that that's part of it. I mean, the Climate Act had some effect. We can't say that it didn't have any effect, which is basically what the New York Commission has said.
Right, Your Honor. And the commission recognized that the nature of the inquiry that the New York ISO has to make, which is to estimate investor expectations of recovery for a gas plant into the future, is necessarily a forward-looking assumption. And this is discussed in the October 2023 order at paragraph 43 and the May 2023 order at paragraph 35. But the point of the commission's anti-speculation precedent is when the New York ISO makes that judgment about investor expectation of risk, It should not incorporate into that judgment any speculation about the law changing in the future, laws and regulations. No speculation about laws and regulations changing in the future. And so that's why in this case, the commission said that it's appropriate to think that an investor today would see additional risk from the fact that there has been this 2040 zero emission requirement imposed.
So the speculation is only about laws? It's not about scientific development or changes in the climate or any of that stuff? It's just laws? Is that what you're saying?
Well, the anti-speculation precedent specifically goes to the, as this court said in its remand decision, FERC's precedents required the New York ISO to take into account currently effective laws and regulations and avoid speculating about laws and regulations in the future. And that was the anti-speculation
That's the
precedent.
remand decision?
Yes, Your Honor, at page 2 of the remand decision. And it cited to the Commission's 2014-2017 demand curve reset order at paragraph 74, which says the same thing, that it is specific to currently effective laws and regulations, because to estimate the investor expectations necessarily requires some forward-looking assumptions on the part of the New York ISO. But the point is to sort of cabin those forward-looking assumptions. They're required to just use the current state of the law as a basis for estimating the investor's expectations.
And how do costs come in here? Because there's projected millions of dollars if you use the 17-year amortization schedules. So how did you all balance that?
The point is, this is a 205 filing that only has to do with the demand curve reset, which is the parameters of the cost of new entry for a new peaking plant. The tariff specifies, once there is a reasonable estimate of the cost of new entry, the tariff specifies then how the resulting rates are calculated. And in this 205 proceeding, the tariff is not at issue. And so, as the commission said, what happens is that once you have a just and reasonable cost of new entry, the resulting rate results from the previously approved rate design. And therefore, if they want to challenge, if they think that the tariff results in unreasonably high rates, they can file a complaint under Section 206 to challenge the tariff and to challenge the rates that result from the tariff. But in this 205 proceeding, where the tariff is not at issue, it's beyond the scope of this proceeding.
Is this Climate Act subject to a test under the Federal Clean Air Act? In other words, does EPA have a preemptive authority?
I don't know the answer to that,
FERC
Your
doesn't
Honor.
control emissions, does it?
No, Your Honor.
No. So, and I thought that there's a general requirement for national ambient air standard, quality standards, that the FERC puts into effect. One state, California, is exempt, but I wasn't sure whether New York was exempt too.
I don't know the answer to that, Your Honor. But I mean, there are
That would
emissions.
call for speculation, right?
Well, there are other provisions of the Climate Act which go to other departments, which go to specific emissions limits and that sort of thing. But I'm not aware that this particular provision has Clean Air Act implications.
There are no lawsuits that you're aware of challenging the validity of it?
The Climate Act?
Right.
Not that I'm aware of, Your Honor.
Right.
My colleagues
If there-
have additional questions?
No further questions?
Thank you.
Thank you.
Thank you, counsel. From interveners now, Mr. Hughes.
Thank you, Your Honor. Paul Hughes for Interveners, Independent Power Producers of New York. I just touched briefly on 3 points, the lack of regulations and speculation. Second, the risk calculus, and third, governing 205 standard. First, on the fact that there are no regulations, as the court pointed out, New York has missed its deadline for implementing regulations. And FERC specifically found at paragraph 38, JA 408, that increases the aggregate risk that investors face because they don't know what the future looks like. And that aggregate increase in risk only supports the proposal that NYSO made. Additionally, in IPNY 1, this court said the PSC has not exercised its discretion to modify the Act's zero emission target and given no indication it ever would. So the baseline is we know there is a zero emission target. In fact, it's a requirement in the law. Now, it could be modified, but as investors currently confront the situation, it has not been done so. And I think that's the baseline that this court in its prior decision already set forward, and that establishes the reasonableness of the action. The second point, though, is the risk more broadly. As FERC explained at paragraphs 42 and 34 and 33 of its decision, that even if there is alternative options that allow these thermal plants to continue running post-24, they're most likely going to be vastly more expensive because they'll either use renewable natural gas or hydrogen or some other technology that is unproven at this point that has a much, much higher price point. And so that goes to, well, first, it's not even clear that it's technically feasible, is what FERC said. It may not exist. But if it does exist at 2040, the evidence shows it's almost certainly going to be vastly more expensive. And that's ultimately what has the effect on the uncertainty. The last quick point is under Section 205. The standard here is very demanding. This is not about what the best rate is. It is whether or not this is a just and reasonable rate that's proposed by NYSO. And FERC was well within its authority to find that this was within the zone of reasonableness. And finally, New York can make decisions about its generation mix, and its policy decision may be a very good decision for 2040, but that does have an effect on costs, and that needs to be taken into account by developers, ensuring that there is sufficient incentive to develop the kind of capacity that New York wants in 2040 in the future. And I think that is the natural effect of its
Just ask
decision.
a little bit about, we've had some discussion about this speculation. And the way I understand it, there's a speculation with respect to the generators, but the Climate Act did not require generators to be ceasing operations, if you will, by 2040. They're allowing New York to set up its program to actually come into compliance with the Climate Act. And so when I'm thinking about my question on speculation, I'm talking about you can't figure out your plan based on speculation of the implementing regulations that have not been yet on the books.
Yes, sir. And I'd answer that in two different ways. The first is, as I think this court understood speculation the last time this case was before the court, was the court said to reduce speculation, we take the Climate Act as the baseline, which says there's no fossil generation by 2040. But there is an unless in there, and I appreciate there's an unless. There could be other sorts of regulations that New York Public Service Commission could implement. But the question is, until those are implemented, what is the baseline that investors understand? And unless and until there's an exception that is put in place, the investors understand the baseline today is what the law requires. And that's what this court very clearly said in its opinion, is that unless there's an exception, that there will be no thermal generation. So as a result, that massively increases the risk. Now, it could be the case. The speculation is maybe, as New York says, things will change. But the reason that we don't think about what may happen down the road is because we're trying to understand the risk profile that investors today are saying, should I build new capacity in New York? What is that going to look like? They have to understand what the cost of the return on their investment is. The second point, though, is even if we were to engage in the speculation that New York suggests, where they say, well, there may be ways that those thermal plants still has some utilization with hydrogen, with renewable natural gas. Those are the sorts of proposals that are being considered. Even if we were to engage in that speculation, that is vastly more expensive for the generator, and those technologies are not proven. So we start engaging in technological speculation. Is there even grid level hydrogen, renewable natural gas that will be available in 2040? We don't know. That's speculation. And if so, it's almost assuredly going to be vastly more costly. All of that goes into why it was appropriate for the New York.
But is your decision based on any speculation about the future regulations?
No, Your Honor, we say the way that this minimizes, and I think this accords with what this court said the last time, is we take the Climate Act as given, which it currently says that there is no emissions post 2040 unless New York PSC does something in the future. Now, there is an ongoing
But
reset.
it doesn't impose any requirements with respect to the generators in the Climate Act.
It does impose, though, a requirement on PSC. And the issue is that it's what is a reasonable investor, a developer of a new plant going to understand? Do I invest the hundreds of millions of dollars required to bring new capacity to New York? What's the return on that investment going to look like? That decision they have to make today based on what they currently understand the baseline law to be. And that's where I think.
Are you aware of any new construction?
Well, I'm not, Your Honor, to the extent, though, that there has been proposals for new construction. We talk about this in briefs, the Astoria and the dance camera plants. The New York Department of Environmental Conservation has denied permits for thermal plants on the basis of the Climate Act. What the New York Department of Environmental Conservation has said is building new thermal units is inconsistent with the Climate Act's requirements of zero emissions. So to the extent that there's been permitting applications that have been requested from the Department of Environmental Conservation, those have been so far denied on the basis of the Climate Act. And what I think that suggests is, to the extent New York is pushing for a different sort of peaking facility, such as batteries and other zero emission options, that is within the prerogatives of New York to select its generation mix. But those are more expensive alternatives for having the peaking capacity that the people of New York need. So as
your point is, if you're an investor looking out ahead, the Climate Act is just a real thing. It was enacted, it's a law, so you have to take that into account in charting the future. If there were regulations in effect, those would be real things too, but there's just not. And there wasn't at the time that the 20 years was reduced to 17. If those regulations come into being and that changes the outlook, that changes the horizon, then in the next cycle, that'll be taken into account. But as it stands now under our remand order, the existing legal state of affairs is that there is a Climate Act, there are no regulations. And then you have to ask, okay, well then what does the road ahead look like in that universe?
That's precisely right, Your Honor, and that's why there's a reset every 4 years to take into account developments.
But in doing that, are you telling me now that you're not looking at what those regulations may state or what you project them to do?
Well, Your Honor, to minimize speculation, we look at what the laws on the books today are, and the laws on the books, the Climate Act is.
And that's what I'm trying to get you to get to. You're only focusing on the Climate Act, or are you also considering future implementing regulations?
What I think this court's decision in the first case said is we look at what laws are on the books today, and the Climate Act exists. There is the possibility that regulations could create exceptions to it, but it's speculative if and when that will occur. We're already more than 2 years past the deadline requirement for those regulations to come. We don't know if and when they will come. And so that's why I think this court said the last time, the baseline is the Climate Act is, as Your Honor said, is a real thing. It exists. It bears on the risk that current developers must take into account when considering what actions or investments to undertake. And if that changes, then that will be addressed in the next reset period. But as it exists today, understanding the costs and benefits of a potential new infrastructure project.
But without the regulations, are there any real requirements with respect to the fossil fuel or the generators?
Yes, Your Honor. I think, and to the extent that there's any doubt about that, what I just mentioned about the Astoria and the dance camera plants demonstrate quite clearly that the New York Department of Environmental Conservation is quite clear that this has a real today meaningful effect in saying that licenses for new thermal generation are being denied on the basis of the Climate Act. So that does have a very, I think, meaningful, clear implication that the Climate Act is real, that it has real meaningful obligations. And again, there's nothing wrong with New York making a decision about its generation mix for public policy reasons that New York seeks to foster. It just has implications for the cost of new capacity in the state when those decisions are made and what that does to forward-looking investment.
Is there a legislative history for this Climate Act? A committee report or reports where their hearings were held?
Your Honor, I don't think there is particularly good pre-enactment history. What we've pointed to in the briefs is the best that we found, I think anyone's uncovered, which was there was a memo, a governor signing statement, and then a majority member remarks at the time of the signing, all of which identify moving New York off fossil fuels. We talk about that in the briefs.
But no hearings that you're aware of?
I'm not aware of a particular committee reports, Your Honor, that go into detail about this. It was rather done by
Does New York in general prepare the legislature? Does the New York legislature in general, some states don't, prepare committee reports?
Your Honor, I don't know generally the answer to that question. I do know we did look here, and so far as I'm aware, we had not.
And you're
found
not
anything.
aware that your clients that would have testified in any hearings that were held on this?
My client is active in these issues. So for example, it was noted there was a comment period for the current regulations, and my client has participated in that.
I'm talking about the statute.
I understand, Your Honor. I'm just making the point broader that my client is active. I'm not aware, though, of any statements that they made. I'd be happy then to research that and provide a letter to the court if they did.
Thank you, counsel.
Thank you, Your Honor.
Mr. Schwartz, we'll give you the 250 you had left.
Thank you. There's a lot there. First, as to Dan Scammer, the permit denial goes to whether this is the right reference unit, not whether fossil fuel resources that are built will have to retire. Furthermore, that decision's reliance on the Climate Act provisions that we're talking about here was vacated by a subsequent ruling of the ALJ, who then stayed further proceedings precisely to wait for the New York Commission to issue implementing regulations. Now, the other side said that it's not speculating about implementing regulations. It absolutely is. The 17-year amortization period reflects modeling parameters that fossil fuel resources will cease operating by 2040 to meet Climate Act requirements. But FERC has said the Climate Act does not require fossil fuel retirement. They absolutely are speculating that that's what the implementing regulations will do. It is no more speculative, however, to assume that fossil fuel resources.
It doesn't require it if your client passes regulations modifying it. Your client has not done that. So until you do that, it does require.
No, it has done neither. Right now, there are no regulations on the books. Nobody could go to court and cite the Climate Act or any regulation of the New York Commission or the DEC to force.
They can't cite a regulation because there aren't any.
Correct. And they could not force the closure of any specific fossil fuel generator.
It's not 2040 yet.
Now, let's discuss what the state of the law was when the system operator filed in November of 2020. At that point, there was a Climate Act that required two things: emission reductions and reliability. There were no implementing regulations. FERC has admitted that the act of its own force does not require retirements, can be implemented in more than one way, hasn't been implemented, does not define zero emissions or tell the New York Commission how to measure emissions, that it can be implemented on a net emission basis that would let fossil fuel resources keep running, and that it requires the New York Commission at every stage, both initially and thereafter, to consider reliability. And FERC itself has reviewed the evidence and found that fossil fuel resources are likely to be needed for reliability after 2039. So the question in this case comes down to, on that record, whether the mere existence of the emission reduction goal without any more justified imposing hundreds of millions of dollars in extra costs on consumers, even though those costs might never be needed. And remember, FERC said 20 years remains reasonable. The system operator can keep running the system reliably today on the basis of the existing amortization period. As for the New York Commission and its implementation of the law, again, in November 2020, the New York Commission wasn't even yet on the clock to have issued implementing regulations. That was 7 months off. In fact, the New York Commission, on the day before FERC changed its mind in this case, opened a proceeding to define zero emissions. That proceeding is underway. Comments have been recently received. New York is working avidly to try to implement the law. The first step it took in October 2020 was to try to promote the development of massive amounts of new renewable resources. But nobody is here saying, and FERC has not found, that by itself is sufficient to allow the closure of the fossil fuel plants. Finally, one last point, Your Honor. The Federal Power Act requires balancing investor and consumer interests. All you've heard on the other side is investor, investor, investor. We're here representing the consumers, and the court should vacate.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.